Imagine you take your trash out to the curb. It's like a Tuesday night.
Right, just a normal chore.
Exactly. The bags are tied up tight. It's your property and it's sitting right outside your house. But the moment that bag actually hits the pavement,
It's gone.
yeah, you have just legally surrendered all your constitutional privacy rights to whatever is inside it.
Just by putting it on the curb.
It's wild.
Ah.
But welcome to our deep dive into the source material on the scope and limits of Fourth Amendment search protections.
That's a big one today.
It really is. Now listen, if you are sitting for the multi-state bar examination, the MBE, or honestly, if you're just fiercely curious about your constitutional rights and like how the law actually views your privacy, this right here is your ultimate survival guide.
Absolutely.
Today's goal is to translate these really dense, sometimes totally contradictory legal doctrines into just simple, plain English.
Which is desperately needed. I mean, let's be honest.
Right. We are going to decode the jargon,
Yeah.
look at the fascinating logic behind these rules, and really highlight the exact traps that exam writers just love to set.
And it is a really critical mission because when you look at the source material, I mean, the Fourth Amendment is basically a masterclass in nuance.
Yeah.
The text itself is, it's remarkably brief. It just guarantees the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures.
Right. It's like 20-something words.
Exactly. But the application of those 20-odd words has generated centuries of, well, really complex legal battles.
Oh, sure.
And knowledge is most valuable when it's understood and applied. So to apply it, we have to start at the absolute bedrock foundation. We have to identify the who.
The who. I actually love starting there because I feel like we always jump straight to what the police are doing.
Yes. All the time.
Right, without even asking if the rules apply to the person doing the action in the first place. Because the Fourth Amendment, at its absolute core, is a restraint on the government.
That's it.
It's a leash on the state. It only applies to governmental action.
That is the threshold right there. It is
Yeah.
everything. If your nosy private citizen neighbor decides to snoop through your backyard.
Which happens.
Oh, totally. If they peer through your bedroom windows with binoculars or dig through your personal files, the Fourth Amendment just does not care.
Wow. Even though it feels like a huge violation.
Right. I mean, you might have a civil lawsuit for trespass or invasion of privacy against that neighbor under state law, sure.
Right.
But there is no constitutional violation.
Because they aren't the state.
Exactly. The Constitution was drafted to protect citizens from the awesome coercive power of the sovereign. The government that actually has the power to lock you in a cage.
Right.
Your neighbor doesn't have that power.
Okay, I am tracking the logic, but let's unpack this with a hypothetical.
Yeah.
Because I know exactly how tricky these MBE scenarios can get.
Bring it on.
Okay, what if I am the government? Like, what if I'm a police detective investigating a major case, and I know I just don't have enough evidence to convince a judge to give me a warrant to search a house.
Okay. Pretty common scenario.
Right. But I also happen to know the suspect's neighbor is incredibly nosy and, actively hates the suspect.
I see where this is going.
What if I, as the detective, essentially ask that nosy neighbor to go over there, hop the fence, and snip around for me?
Yeah, well, the law anticipates exactly that kind of loophole.
Oh, it does.
Oh, yeah. The jurisprudence is incredibly clear here. The police may not circumvent the Fourth Amendment by intentionally enlisting private individuals to conduct a search.
Okay.
So if a police officer requests, directs, or even just implicitly encourages a private citizen to act on their behalf, the legal mechanism of agency kicks in.
Ah, meaning the neighbor becomes like a temporary arm of the state.
Precisely. For the purpose of that specific search, the private citizen transforms into a government agent. The government's fingerprints are on the action.
Which changes everything.
It changes everything. It means the heavy machinery of the Fourth Amendment is immediately triggered. The search is scrutinized exactly as if a uniformed officer had kicked down the door.
Okay, but the causal link is the magic ingredient there, right?
Yeah.
What if the neighbor acts completely on their own initiative?
Right, that changes the entire legal landscape.
Because the police didn't ask them to.
Exactly. If the neighbor breaks into the house entirely unprompted, finds, say, a bloody narf, and then voluntarily brings that evidence to the police station.
And police can just take it.
They can absolutely use it in court. There is no Fourth Amendment violation because the government did not initiate or encourage the intrusion.
Wow.
Yeah, the Constitution doesn't punish the police for the independent illegal acts of private citizens.
Okay, so if you are sitting in the exam room tomorrow,
Yeah.
here is your non-negotiable mental flowchart for these questions.
Listen up to this. Yeah.
Rule number 1. Whenever you see a search in a fact pattern, aggressively check the identity of the actor. Is it the government?
Always ask that first.
Right. If it's a private citizen acting entirely on their own, stop your Fourth Amendment analysis right there. It does not apply.
Mm-hmm.
But if the police intentionally enlisted them, the Fourth Amendment does apply. Start with the who every single time, or, man, you will fall for a classic distractor answer.
You really will. You simply cannot analyze a search until you confirm the state is the actual one doing the searching.
Right. So, okay, now that we've established who the amendment restrains, we run into this really fascinating semantic problem.
Semantic how?
Well, in the real world, searching just means looking for something, right? I search for my keys, I search for a good restaurant on my phone.
Sure.
But in constitutional law, a search is a highly specific, fiercely debated legal trigger. It requires a specific set of circumstances to occur.
It does, and this is really where the philosophy of the law meets the mechanics of the law. Not every time a police officer looks at something or observes something is it considered a search under the Constitution.
Right.
The Supreme Court has spent decades refining this two-pronged trigger to define exactly what constitutes a search. And it's vital to understand that this is an or test.
An or test. Okay.
Yeah. If the government's action satisfies either prong, a search has occurred, and Fourth Amendment protections apply.
Okay, let's break down those prongs. I know the first one represents a massive historical shift in how the courts viewed privacy.
It really does. So prong 1 basically states that a search occurs when the government invades a place where an individual has a reasonable expectation of privacy.
Okay.
And this doctrine, it was birthed in the legendary 1967 case, Katz v. United States. To understand the rule, you kind of have to understand the history.
Laid on me.
So before Katz, the law was rigidly tied to physical property. The courts asked a simple question. Did the police physically trespass onto your land or break into your house?
Like, did they cross a property line?
Exactly. If there was no physical trespass, there was no search.
Wait, so under that old rule, if the police could eavesdrop on you without physically touching your property, they were totally in the clear.
They were in the clear, but Katz blew that entire framework wide open.
What happened in Katz?
So Charles Katz was a bookie. He used a public glass telephone booth on Sunset Boulevard to transmit illegal gambling wagers.
Okay, a public phone booth.
Right. And the FBI, they didn't physically break into the booth. They just taped an electronic listening device to the outside of the glass.
Clever.
Yeah. And under the old property rules, this wasn't a search because there was no physical trespass into a space Katz actually owned.
I mean, he was standing on a public street in a glass box, visible to the whole world.
Exactly. But the Supreme Court issued this monumental ruling. They famously declared that the Fourth Amendment protects people, not places.
Protects people, not places.
Yes. They said when Katz walked into that booth and shut the door behind him, he paid his toll, and he reasonably expected that his conversation would be private.
Right, because he closed the door.
Exactly. The court ruled that society is prepared to recognize that expectation as reasonable. Therefore, electronically invading that expectation of privacy constituted a search, regardless of whether a physical trespass occurred.
Protects people, not places. I just love how fundamental that feels. It moves the protection from the bricks and mortar of a building directly to the actual human being.
It was a massive paradigm shift.
So that is prong 1, invading a reasonable expectation of privacy. But the second prong seems to bring us right back to the bricks and mortar.
It does. It really does. Because the Supreme Court eventually realized that focusing solely on the expectation of privacy actually created blind spots.
Oh, interesting. Like what?
Well, so prong 2 is the physical intrusion test. Even if a judge decides you don't have a modern expectation of privacy in a certain scenario, a search also occurs if the government physically intrudes upon a constitutionally protected area.
Which are the ones listed in the text, right?
Yes, exactly. Persons, houses, papers, or effects. If they intrude on those for the specific purpose of gathering information, it's a search.
I'm struggling to see the physical difference here in modern application. Like, if the goal is to protect privacy, why do we need a separate rule just for physical touching?
Because the physical trespass rule protects against government overreach, even when your subjective expectation of privacy might be really low.
Okay.
The sources highlight 2 modern cases that perfectly illustrate this. Florida v. Jardines and United States v. Jones.
Oh, let's look at Jardines first. This is the 2013 case involving the drug-sniffing dog on the front porch, right?
Correct. So in Jardines, police officers walked a highly trained drug-sniffing dog right up onto a suspect's front porch to see if they could smell contraband inside the house.
Okay, but a front porch is pretty much exposed to the public. I mean, mail carriers, delivery drivers,
Well,
Girl Scouts, they walk up to your front porch all the time.
right.
So you don't have a total expectation of privacy from people just approaching your door.
You don't. But a drug-sniffing dog is not a Girl Scout.
Fair point. Very different vibe.
Right. So the Supreme Court ruled that while there is an implied license for the public to walk up to your door, knock, and wait to be received, there is absolutely no implied license for the police to bring a specialized sensory tool onto your property for the sole purpose of gathering forensic information.
Wow.
Yeah. That is a physical intrusion upon a constitutionally protected area, the immediate surroundings of the house. Therefore, it is a search.
Okay, that makes sense. And the Jones case takes this physical intrusion concept from the front porch out to the driveway.
It does. United States v. Jones in 2012 is this really fascinating collision of old property law and modern technology.
What did they do?
The government secretly placed a GPS tracking device on the undercarriage of the defendant's vehicle to monitor its movements around the city for a whole month.
Now wait. If I drive my car on public roads, literally anyone can see me. I have zero expectation of privacy regarding my movements on a public street.
Right.
So under the CATS test, tracking me shouldn't be a search at all.
And the government argued exactly that. They said Jones had no reasonable expectation of privacy on public roads.
But they lost.
They lost. The Supreme Court countered by applying the physical intrusion prong. They ruled that the vehicle is an effect under the text of the Fourth Amendment.
Ah,
So when the government agents literally slapped the tracker onto the metal of the car, they committed a physical trespass upon that effect for the explicit purpose of gathering information.
So it's the actual act of touching the car to install the device that trips the constitutional wire.
Exactly.
It's a fascinating revival of the old property rules to deal with a 21st century problem.
Okay, so to ensure our listeners have this locked in, a search happens if the government invades your reasonable expectation of privacy or if they physically trespass on your protected property to gather information. It is a dual shield.
It is a dual shield,
Yeah.
but, and this is a big but, that shield only protects you if you are the one holding it.
What do you mean? Well, this brings us to a critical, highly tested concept in the source text. It is the concept of standing, and it is honestly the ultimate trap for the unwary exam taker.
Okay, let's lay out the trap. Because my instinct is always to say, look, if the police break the rules, the evidence gets thrown out, period.
Right, and that instinct will cause you to fail the question.
Ouch.
Good to know. The trap involves fact patterns, where the government clearly conducts an illegal, unconstitutional search, but the individual trying to suppress the evidence has no expectation of privacy in the specific place that was searched.
Okay, let's build a hypothetical around this, just make it concrete.
Sure.
Let's say I am visiting an acquaintance's house. I'm not like an overnight guest. I just stopped by to drop something off.
Okay, casual visitor.
And while I'm sitting in the living room, the police completely illegally bust down the door without a warrant, without probable cause, without anything.
A blatant violation.
Total violation. They tear the house apart, and they find my backpack sitting in the corner. They search the backpack and find illegal contraband that belongs to me.
Uh-oh.
Can I claim a Fourth Amendment violation to get that contraband thrown out of court?
No, you cannot.
Why not?
And this is where the logic of the law feels so brutal to a layperson. The Fourth Amendment right is a personal right. It cannot be asserted vicariously.
Meaning I can't use someone else's rights.
Exactly. In your hypothetical, the police absolutely violated the homeowner's Fourth Amendment rights by kicking down the door. The homeowner's reasonable expectation of privacy was shattered.
Right.
But your privacy, you were merely a casual visitor. You had no legitimate expectation of privacy in the overall structure of someone else's house.
But wait, they searched my backpack. I definitely have an expectation of privacy in my own backpack.
You do? But the police only reached your backpack by exploiting the illegal entry into the house. Since you cannot complain about the illegal entry into the house because it wasn't your house, you cannot challenge the subsequent discovery of the backpack.
Wow.
Yeah. You cannot wrap yourself in the homeowner's constitutional rights. The government's action is totally valid against you, even though it was invalid against the homeowner.
That is a harsh reality.
So the mechanism here is exclusivity. You can only complain if the government violated a space that belongs to you or a space where society recognizes your personal expectation of privacy.
That is exactly right.
So, for the exam takers, never assume that just because the police acted badly, the defendant automatically wins. You must draw a direct line between the government's illegal action and the specific defendant's personal expectation of privacy.
Yes.
If the defendant had no privacy interest in the location searched, they lose,
Mhm.
regardless of how blatantly the police broke the rules.
That direct line is the absolute core of the analysis.
Yeah.
You must always link the right to the specific defendant.
Okay, which naturally drives us to the next massive section of our deep dive. Since this entire concept of an expectation of privacy relies so heavily on where you are and what your connection to that specific place is, we really need to map out the geography of the Fourth Amendment.
Let's do it.
And the undisputed king of that geography is the home. Location, location, location.
The home is the fortress. The source material emphasizes that while Katz taught us the Fourth Amendment protects people, not places, the text itself explicitly lists the house as a protected area.
Right.
When it comes to reasonable expectations of privacy, the interior of your dwelling is the absolute gold standard.
Let's define dwelling, because a lot of people don't own a freestanding house with a white picket fence. Does this protection apply if I just lease an apartment?
Absolutely. The protection extends to any person who has the right to immediate possession of a dwelling space.
Okay.
That unequivocally includes the renter of an apartment. It also includes a college student living in a dormitory room. The 1961 case, Chapman v. United States, solidified that renters enjoy this full, robust protection.
So my landlord can't just let the cops in?
No. The landlord cannot simply grant the police permission to search your rented apartment. If it is your dwelling space, it is your castle, regardless of whose name is actually on the deed.
Okay, so the interior of the dwelling is clearly protected. But what happens when we open the front door and step outside?
Now we get into the yard.
Right. The source text introduces a wonderful, somewhat archaic legal term for this, curtilage. How does the law define the space immediately outside the house?
Curtilage is such a vital concept. I like to think of it as an invisible umbrella of protection that opens up over the roof of your house and casts a shadow over the immediate surrounding area.
Oh, I like that. The umbrella analogy is perfect. Under the umbrella, you are protected. Step outside the umbrella, you get wet.
Exactly. The area immediately surrounding the home, the curtilage, is treated legally as if it is part of the home itself. You have a reasonable expectation of privacy there.
Okay.
But defining the exact circumference of that umbrella is incredibly fact-dependent. There's no glowing neon line on the grass separating the curtilage from the rest of the world.
All right, there's no chalk outline. So how do the courts figure out where the umbrella ends?
They use a four-factor balancing test established in the landmark case United States v. Dunn. Courts basically have to weigh these four factors to determine if an area falls within the curtilage.
Okay, let's walk through these four factors, because this feels like prime material for an essay question on the bar.
Oh, absolutely. First factor, proximity. How physically close is the area in question to the home itself?
Okay, proximity.
Second factor, enclosure. Is the area included within an enclosure that surrounds the home, like a fence or a wall?
Enclosure, got it.
Third factor, the nature of the use. What is the area actually used for? Is it used for the intimate, daily domestic activities associated with home life, like a patio where you eat dinner or a swing set where your children play?
Makes sense. And the fourth factor?
Fourth is steps taken to protect privacy. What specific actions has the resident taken to shield the area from the observation of people passing by? Did they plant thick bushes? Did they put up a tall privacy fence?
Okay, so proximity, enclosure, use, and steps taken to hide it. The sources provide a very detailed fact pattern from that Dunn case, involving a barn on a large piece of property. Let's really analyze this barn using the four factors to see how the court builds the argument.
The facts of Dunn are perfect for this. So, drug enforcement agents suspected a property owner was manufacturing illegal drugs in a barn. They crossed several fences, went right up to the barn, and shined a flashlight through netting to look inside.
And these all drugs?
They saw a drug lab. And the entire case hinged on whether that barn was under the umbrella of the curtilage. Let's apply the test.
All right, factor one, proximity. Where was the barn?
The barn was located 60 yards away from the main house.
60 yards.
That is more than half the length of a football field. The court viewed that as a substantial distance, so proximity weighs heavily against it being curtilage.
Makes sense. Factor two, enclosure. Were they in the same fenced-in area?
No. The main house had a fence around it, but the barn was located 50 yards outside of that innermost house fence.
Oh, wow. Okay.
Yeah, the barn had its own separate fences, but it was not enclosed together with the dwelling. So enclosure weighs against curtilage.
Okay. Factor 3, the nature of the use. Was it used for intimate home activities?
The objective evidence showed the barn was used for commercial or agricultural purposes, not intimate domestic life.
Ah.
I mean, the smell of chemicals emanating from it certainly didn't point to a family barbecue.
Right. Definitely not.
So the use factor weighs against curtilage.
3 strikes. And the fourth factor, steps taken to protect privacy.
Well, the owner did have fences around the barn, but they were typical ranch fences, post and wire.
You could see right through them.
Exactly. They were see-through. They were designed to corral livestock, not to prevent people from looking onto the property.
So when you aggregate all 4 factors, the barn is clearly out in the cold. It's not under the umbrella.
Consequently, the Supreme Court ruled that the barn and the area immediately surrounding it lay outside the curtilage. It was not under the home's umbrella. Therefore, the drug agents sneaking up to it and looking inside did not commit an unreasonable search under the Fourth Amendment. It was fair game.
Man, that is a masterclass in applying facts to a legal test. And this barn example transitions us seamlessly into the next doctrine. If an area falls outside the curtilage umbrella, what is it legally considered?
It falls under what is known as the open fields doctrine, which was established in the case United States v. Oliver.
Open fields.
Yes. Private property that lies outside the curtilage, whether it is a farmer's crop field, a dense wooded forest, or an empty pasture on a large estate, is fundamentally not protected by the Fourth Amendment.
Seriously?
Yeah. Governmental intrusion upon an open field is simply not a search.
Wait. If I put up a 10-foot barbed wire fence around my 100-acre woods and I plaster neon orange, no trespassing violators will be prosecuted, signs on every single tree along the perimeter, how is that an open field? I am screaming to the world that this is private space.
This is a vital philosophical distinction in the law. By putting up those fences and signs, you are demonstrating a clear, subjective expectation of privacy.
Right. In my own mind, I intend for that area to be private, and I took actions to make it so. I clearly don't want anyone there.
But remember the Katz test. An expectation of privacy must be both subjective and objectively reasonable, meaning society is prepared to recognize it as legitimate.
Oh, right. The second half of CAPS.
Exactly. The Supreme Court has ruled that society does not objectively recognize an open field as a protected sanctuary in the same way it recognizes a home. Historically, open fields are accessible to the public, to hunters, to wandering livestock.
Right.
Therefore, no matter how many signs you put up, an open field fails the objective test.
So the mechanism here is the difference between state trespass law and federal constitutional law. Like, a police officer hopping your barbed wire fence might be committing the state-level crime of criminal trespass. And you could theoretically sue them for that. But they are not committing a Fourth Amendment search. The constitutional shield just does not extend to the forest.
That is exactly right. A trespass is not automatically a search.
Okay, let's look at another location scenario that frequently trips people up. We've established the home is the fortress. But what if I am not in my home?
Okay, you're traveling.
Yeah. What if I'm traveling or crashing with a friend? How far does my personal umbrella of protection travel with me into other people's spaces?
The courts have drawn a very specific, fascinating line regarding temporary visitors, and it is heavily tested. Let's compare two landmark cases, Minnesota v. Olson and Minnesota v. Carter.
Let's start with Olson.
In Olson, the defendant was an overnight guest in another person's home. The police entered the home without a warrant and arrested him.
Okay.
The Supreme Court ruled that an overnight guest does have a legitimate expectation of privacy in their host's home.
Wait, really? Why? It's not their house.
Because society universally recognizes the sanctity of an overnight stay. When you are an overnight guest, you seek shelter, you sleep there, you store your personal belongings there.
You're vulnerable.
Exactly. You are sharing in the domestic intimacy of the home. The court essentially said that for that night, the host's umbrella extends to cover the guest.
That actually makes profound social sense. Now, let's contrast that hospitality with the Carter case.
Minnesota v. Carter involves a very different kind of visit. In this case, two individuals went to an acquaintance's apartment for just a few hours. They did not stay the night.
Okay, so short-term visit.
Very short term. And more importantly, they were there for a purely commercial, illegal purpose. They were bagging massive quantities of cocaine for street sale.
Oh, wow. Well,
And a police officer looked through a gap in the blinds and saw them.
they're basically running a temporary factory in the living room.
Exactly. And the Supreme Court seized on that distinction. They held that a purely short-term use of a home for a commercial transaction does not give rise to a reasonable expectation of privacy.
Even though it's inside a home.
Even inside, these individuals had no prior relationship with the homeowner. They were simply using the space to conduct a business deal. They were treated legally more like workers in a warehouse than guests in a dwelling.
So they couldn't complain.
Right. They had no standing to claim a Fourth Amendment violation when the officer looked through the blinds.
So the mechanism of protection is the nature of the intimacy. Society protects the vulnerability of sleep and personal connection. It does not constitutionally protect a rented room used as an illegal distribution center for 3 hours.
Nope.
The umbrella retracts.
Precisely. The context of the visit dictates the level of constitutional protection.
Speaking of renting rooms, what about a commercial motel? Like, I'm traveling, I pay for a room at a Holiday Inn. Is that my castle?
Yes. The search of a rented motel room by a government agent without a warrant is generally an unreasonable search. For the duration of your rental agreement, that room functions as your temporary dwelling. It enjoys the full protection of the home.
But motels have staff. The manager has a master key. Can the police just bypass me, go to the front desk, and ask the clerk for permission to enter my room?
Absolutely not.
Really?
Yeah, the controlling case here is Stoner v. California. The Supreme Court ruled that a motel clerk's consent to a governmental search of a room during the rental period is legally meaningless.
Okay, good to know.
The clerk has the authority to enter the room, to clean it, or to do maintenance, sure, but they do not have the authority to waive your constitutional rights on your behalf. Only the occupant can consent to a search of their temporary dwelling.
The landlord cannot sell out the tenant. Got it.
Okay.
Okay, before we leave the geography of the Fourth Amendment, let's touch briefly on two extreme ends of the spectrum, businesses and prisons.
Okay, sure. In general, commercial business premises are protected by the Fourth Amendment. The police cannot simply barge into a private accounting firm's back office without a warrant to look for evidence of embezzlement. However, there is a major caveat. Businesses in highly regulated industries are subject to administrative searches, which have a much lower threshold for entry to ensure regulatory compliance.
Oh, like think health inspectors at a restaurant or federal agents checking firearms records at a gun shop.
Exactly. You operate in those industries knowing the state will be looking over your shoulder.
Makes sense. And the other extreme, prisons. I imagine the umbrella of protection is non-existent there.
It is entirely non-existent. In Hudson v. Palmer, the court made it unequivocally clear. A prison inmate has absolutely no reasonable expectation of privacy in his cell.
None at all.
None. The overwhelming institutional need to maintain security, prevent violence, and find contraband completely overrides any residual privacy interest an inmate might claim. A prison guard can search a cell at any time, for any reason, or for no reason at all.
What about people who haven't been convicted yet? Like pretrial detainees sitting in the county jail waiting for their day in court.
Pretrial detainees have a marginally different status conceptually, but practically their cells are still subject to routine, unannounced searches.
Okay.
Furthermore, in the case of Florence v. Board of Chosen Freeholders, the Supreme Court ruled that jail administrators can constitutionally require all arrestees who are being committed to the general population to undergo highly invasive visual strip searches.
All of them. Even if someone is just arrested for an unpaid traffic ticket.
Yes, even for minor offenses, and even without any reasonable suspicion that the specific individual is hiding weapons or drugs.
Wow.
The court deferred to the severe security challenges of managing a jail population. The intake process is a vulnerable moment for the facility, and the security needs trump the individual's dignity.
Okay. To make sure our listeners have this locked in, if you are analyzing locations for the bar exam, build this mental map. Your actual home, your rented apartment, or your dorm room. Highly protected.
Yep.
The curtilage immediately surrounding that home. Protected, using the Dunn four-factor test. An overnight guest sleeping on a couch. Protected. A rented motel room. Protected, and the clerk cannot consent for you.
All highly protected.
But step into the open fields. Unprotected, regardless of fences. A house used briefly just to bag cocaine. Unprotected. And a prison cell, a constitutional void.
Exactly. Keep the nature of the space clear and the rules will naturally follow. That geographical framework will solve a vast majority of the location-based questions you encounter.
Awesome. But if the home is the ultimate fortress, What happens when we voluntarily leave that fortress and step into a highly regulated machine on public roads?
The car.
The car. We are shifting to Section 3, automobiles and the open road, because it seems like cars exist in a parallel constitutional universe.
They absolutely do. The entire framework of automobile searches rests on a foundational doctrine known as the lesser expectation of privacy.
Let's wrestle with that logic, because a car is my private property. I pay thousands of dollars for it. The doors lock, the windows roll up, the glass is tinted. When I am sitting in my car, I feel isolated from the world.
You feel very private.
Yeah. Why does the Constitution view my car so differently than my living room?
Well, the Supreme Court, most notably in Wyoming v. Houghton, articulated two main reasons for this lesser expectation.
Okay.
The first is mobility. A car can be quickly moved out of the jurisdiction before a police officer has time to find a judge and secure a warrant. The evidence can literally drive away.
Okay, that makes practical sense.
And the second reason, and arguably the more philosophical one, is pervasive government regulation.
Meaning the state is already heavily involved in the existence of the car.
Exactly. To drive a car, you must be licensed by the state. The car must be registered with the state. It must have visible license plates.
Oh.
It must pass safety and emissions inspections. You drive it on public thoroughfares that are patrolled by law enforcement. Society simply expects that automobiles will be monitored and regulated in a way that the interior of a home is not.
So it's inherently less private.
Because of that heavy regulation, your expectation of privacy is inherently diluted the moment you turn the key.
I understand the diluted privacy argument, but does that mean the police have carte blanche? Can a patrol car just pull me over on a whim because the officer doesn't like the color of my bumper?
No. And this is a crucial distinction that students often miss. While the privacy expectation in the vehicle is lesser, the actual act of stopping the car constitutes a seizure under the Fourth Amendment.
Seizure of the car.
Seizure of the human beings inside.
Really?
Yes. In Delaware v. Prowse, the court established that stopping a car is a seizure of the driver. And in Brennan v. California, they clarified that a traffic stop also constitutes a seizure of every single passenger in that car.
Ah. Because the moment those red and blue lights flash in the rearview mirror, no reasonable person in that vehicle feels free to simply open the door and walk away. Everyone is legally detained.
Precisely. Because it is a seizure of a person, the Fourth Amendment demands justification.
Okay, so what's the standard?
To make that traffic stop constitutional, the police officer must have an articulable, reasonable suspicion that a violation of the law has occurred. They cannot pull you over on a mere hunch or a gut feeling.
Articulable is the operative word there, right? The officer has to be able to stand up in court and explain exactly what specific objective facts they saw. Swerving over the yellow line, an expired registration tag, speeding, that form the basis of their suspicion.
Correct. The suspicion must be rooted in observable facts.
But building on that, the sources highlight a fascinating detail regarding where those observable facts can come from. It doesn't always have to be the officer's own eyes, does it? The Navarrete case deals with a third-party tip.
Yes, Navarrete v. California. This case addressed whether an anonymous 911 call can provide the necessary reasonable suspicion for a stop.
Okay, how did that go?
A citizen called 911, identified the make, model, and license plate of a truck, and reported that the truck had just run them off the road. An officer spotted the truck shortly after and pulled it over without personally witnessing any erratic driving.
Was the stop legal?
The Supreme Court said yes.
Sit off the call.
Just off the call. They ruled that under the totality of the circumstances, the 911 call bore sufficient indicia of reliability. The caller claimed eyewitness knowledge of dangerous driving. The report was contemporaneous with the event, and the caller used the 911 system, which traces calls and provides safeguards against false reports.
Okay, I see.
Because drunk or reckless driving poses an immediate lethal threat to the public, that reliable tip alone was enough to justify the brief seizure of a traffic stop.
The danger to public safety tips the scale. Let me throw another wrinkle at you, specifically regarding rental cars. This is from the Byrd case.
Oh, this is a fun one.
Let's say my partner rents a car at the airport. Their name, and only their name, is on the rental agreement. But I take the keys and drive the car to the store. The police pull me over.
Okay.
Do I have any Fourth Amendment rights in that car? Or do I lose them because I'm technically violating the corporate rental contract by driving an unauthorized vehicle?
That scenario is catnip for bar examiners. In Byrd v. United States, the Supreme Court ruled unanimously that the driver does maintain a reasonable expectation of privacy.
Even if I'm not on the contract.
Yes, the court drew a sharp line between a corporate contract violation and a constitutional right. As long as you possess the rental car lawfully, meaning you didn't steal it or carjack the person who rented it, the fact that you are an unauthorized driver under the rental agreement does not defeat your Fourth Amendment protection.
I find that deeply reassuring. The Constitution operates on a higher, more fundamental plane than the fine print of an enterprise rent-a-car contract. A breach of contract does not equal the surrender of civil liberties.
That is exactly the reasoning.
Okay, so we've established the rules for stopping individual cars based on individualized suspicion. Now we must enter what I call the checkpoint maze.
The maze, good luck.
This is a massive focus area for the MBE. Sometimes the police don't have any suspicion. They just block off a road and stop every single car that drives by. How does the Constitution tolerate a seizure with zero individualized suspicion?
It is a very delicate, highly scrutinized balance. The court acknowledges that checkpoints are seizures without suspicion.
Right.
However, they are legally permissible if the stop is based on neutral, articulable standards, meaning the police aren't randomly picking and choosing who to stop, and, most importantly, if the primary purpose of the checkpoint is closely, intimately related to an issue affecting the safety of the roadway itself.
Road safety is the key. Let's contrast two major cases from the sources to illustrate this dividing line. Sitz and Edmond.
Let's do it. Michigan Dimmitt of State Police v. Sitz evaluated the constitutionality of sobriety checkpoints. The police set up a roadblock, stopped every car, and briefly observed the drivers for signs of intoxication.
Okay.
The Supreme Court upheld this practice as constitutional.
Because drunk driving is an immediate lethal hazard to the other people using that specific road.
Exactly. The purpose of the checkpoint is to remove an immediate physical threat from the highway. The governmental interest in preventing drunk driving fatalities is immense, and the intrusion on the sober driver, a stop lasting mere seconds, is minimal.
Now, contrast the drunk driving checkpoint with the checkpoint in Indianapolis v. Edmond.
Right. In Edmond, the city set up a roadblock with a different goal. They stopped cars, checked licenses, and then walked a drug-sniffing dog around the exterior of every single vehicle looking for illegal narcotics.
And the Supreme Court struck this down. They ruled it unconstitutional. But I'd argue, aren't illegal drugs also a threat to public safety? Why the different outcome?
The outcome hinges on the primary purpose of the checkpoint. The Supreme Court recognized that the primary purpose of the drug checkpoint in Edmond was to uncover evidence of ordinary criminal wrongdoing. It was general crime control. It was not about the immediate mechanical safety of the roadway.
This is the philosophical line in the sand.
It is. If the court allowed police to set up suspicionless checkpoints merely to look for general crimes, the requirement for individualized suspicion would collapse entirely. Police could set up a roadblock on every corner to check trunks for stolen televisions or glove boxes for illegal weapons. The Fourth Amendment simply does not permit suspicionless seizures for the purpose of general crime control.
Let's use an analogy to cement this for the listener. It is like the difference between a bouncer at a nightclub checking everyone's ID at the door to make sure they are 21. That keeps the club legally compliant and ensures the specific activity inside is safe. That is a sobriety checkpoint.
Good analogy.
Versus a bouncer deciding to walk down the public sidewalk, randomly patting down every pedestrian who walks by, just to see if they can find the person who committed a robbery in the neighborhood last week. You cannot subject the innocent public to a search simply hoping to stumble upon a general crime.
That analogy perfectly captures the distinction. You cannot use the convenience of a checkpoint to bypass the hard work of investigating ordinary crimes.
Makes total sense.
Now, having said that, there is a very specific exception to this no general crime control rule, and it involves witnesses.
Oh, the Litster case.
Yes, Illinois v. Litster. Police can set up a checkpoint related to a crime, but only if the primary purpose is to find witnesses to that crime rather than to catch the occupants of the car committing the crime.
So if a tragic hit-and-run accident happens at a specific intersection on a Tuesday night at 9 p.m., the police can set up a checkpoint at that exact intersection the following Tuesday at 9 p.m. to hand out flyers and ask drivers if they saw anything the week before.
Exactly. But the court requires strict tailoring. The stop must advance a significant public concern like solving a fatal accident. It must target a specific location and time relevant to the crime.
And it has to be brief, right?
Yes. The interference with Fourth Amendment liberties must be minimal. Asking a quick question and handing over a flyer is constitutional. Dragging drivers out of their cars and interrogating them for an hour is not. It is an information gathering exercise, not an investigation of the driver being stopped.
Got it. The checkpoint maze has one more major corridor: immigration checkpoints. Because I know I have driven through massive Border Patrol checkpoints on highways in Texas and California, sometimes 60 miles away from the actual international border. How are those evaluated?
Immigration enforcement operates under its own specific doctrines, largely driven by the concept of national sovereignty. At the actual border of the United States, or its functional equivalent like an international airport customs desk, the rules are incredibly broad.
You essentially have no rights there.
Well, the government can conduct random, suspicionless stops and searches of any car, luggage, or person entering the country. It is a fundamental right of the sovereign to control who and what crosses its borders.
I think most people understand the actual border, but what about those inland checkpoints?
When you move inland, the rules shift. Based on the case United States v. Martinez Fuerte, the Border Patrol is permitted to set up fixed, permanent checkpoints on major highways leading away from the border. At these fixed locations, they can stop all cars to briefly check the citizenship status of the occupants without any individualized suspicion.
Again, the key is the neutral standard. They were stopping everyone.
Yes, but contrast the fixed checkpoint with a roaming patrol. In the Cortez case, the court ruled that a roaming Border Patrol agent driving down the highway cannot randomly single out one specific car and pull it over just to check immigration status.
Oh, interesting.
To make a roving single car stop, the agent must have a particularized and objective basis, reasonable suspicion, to believe that specific vehicle is involved in illegal immigration activity.
So the neutral, fixed checkpoint stopping everyone is permissible. The random roaming stop of a single car requires suspicion.
Exactly right.
Let's cover one last highly specific detail regarding cars before we move on. The vehicle identification number, or VIN.
The New York V-Class case. The Supreme Court ruled that a driver has no reasonable expectation of privacy in the VIN affixed to the dashboard. The government legally mandates that the number be placed there, and it must be visible from the outside of the vehicle. It is a public piece of information.
So what happens if a police officer pulls me over once to check my VIN, but I have a piece of paper or a parking ticket sitting on the dashboard covering it up?
The officer is legally permitted to reach inside the car and move the paper to read the VIN. Because you have no privacy interest in the number, moving an obstruction to see it is not a search.
And here's the exam trap. What if the officer reaches in to move the paper, and while their hand is inside the car, they happen to look down and see an illegal weapon sitting on the floorboard?
The weapon is fully admissible in court.
No way.
Yes. The officer was lawfully positioned inside the vehicle to view a public number, and the weapon was in plain view.
Fascinating. For the bar exam, memorize the dividing lines of the checkpoint maze. Stopping a car is a seizure requiring reasonable suspicion. Sobriety checkpoints. Legal. They serve immediate road safety. Witness checkpoints. Legal, if narrowly tailored to gather information. Border checkpoints. Legal to protect sovereignty.
That's the list.
But drug checkpoints. Unconstitutional, because they are designed for general crime control. Random inland stops by a roaming patrol. Unconstitutional without suspicion. Road safety versus general crime control is the fulcrum upon which these cases balance.
Keep that fulcrum in mind, and the logic of the car rules becomes remarkably consistent.
But the lesser expectation of privacy doctrine creates a massive loophole. If the car itself is less protected, what happens to the deeply personal items we store inside it? Does the constitutional shield drop from my suitcase just because I put it in my trunk? We are moving to Section 4. Your stuff, your secrets, and the terrifying concept called the assumption of risk.
It is perhaps the most sobering doctrine in Fourth Amendment law for anyone who values privacy in the modern age.
Sobering's a good word for it.
The text of the amendment protects papers and effects. Your luggage, your purse, your documents. These are your effects. But the level of constitutional protection they receive depends entirely on how you, the owner, treat them in public. Let's look at the luggage cases to illustrate this.
We have two contrasting scenarios in the sources. Bond and place. Let's start with Bond.
So Bond v. United States. A Border Patrol agent boarded a commercial bus to check immigration status. As he walked down the aisle, he systematically squeezed and manipulated the soft luggage that passengers had placed in the overhead bins above their seats.
Okay, squeezing the bags.
When he squeezed Bond's bag, he felt what he believed was a brick of drugs.
And the court said that physical manipulation was a search.
They did. The court reasoned that while you expect other passengers might occasionally bump or lightly touch your bag in an overhead bin, you have a reasonable expectation that your luggage will be free from exploratory, physical squeezing and manipulation by the government. The tactile exploration crossed the line into a search.
I certainly don't want a government agent kneading my clothes like dough. But compare the physical squeeze in Bond to the sensory sniff in United States v. Place.
Right, in Place, law enforcement seized a traveler's luggage at an airport and subjected it to a sniff test by a trained narcotics detection dog. The dog alerted to the bag.
Okay.
The Supreme Court ruled that the dog sniff itself was not a search.
I'm struggling with the consistency here. How is squeezing a bag a search, but having a dog chemically analyze the air coming out of the bag not a search?
The legal distinction lies in what is being exposed and what is being revealed. When you squeeze a bag, you are learning about private, non-contraband items inside, the shape of clothes, the presence of a book.
Okay, that's true.
But a dog sniff is considered sui generis unique. It only reveals the presence or absence of illegal contraband. Furthermore, the smell of the contraband is emanating out of the bag and escaping into the public air. You are not keeping the odor private.
So it's basically public air at that point.
Because there is no legitimate privacy interest in possessing illegal drugs, and because the dog doesn't reveal anything else about the contents of your bag, the sniff does not compromise a protected privacy interest.
The mechanism is the loss of exclusivity. You let the smell escape into the public domain. And this concept of voluntarily giving up exclusivity is the foundation of the most controversial area of Fourth Amendment law, the third-party doctrine, also known as the assumption of risk.
The philosophy behind the third-party doctrine is brutal but legally absolute.
Okay.
The doctrine states that when you voluntarily give information or property to a third party, you extinguish your reasonable expectation of privacy in that information.
Wow.
The law views privacy as a contract of strict exclusivity. The moment you hand a secret to another human being or a corporation, you break that exclusivity. You are legally acknowledging that someone else has access to this data, which means society can no longer objectively treat it as your private sanctuary. You have assumed the risk that the third party might betray you and hand it over to the government.
Let's look at how this applies to our most sensitive data, our financials. The Miller case from 1976.
Right. In United States v. Miller, the government wanted the defendant's bank records. They didn't get a warrant, they just issued a subpoena to the bank.
Okay.
Miller argued his financial records were intensely private papers. The Supreme Court disagreed. They ruled that when you fill out a deposit slip, write a check, or conduct a transaction, you are voluntarily transferring that information to the bank employees. The bank statements are not your private papers, they are the business records of the bank.
Because you handed it over.
Because you voluntarily conveyed the information to a third party, you assumed the risk it would be shared. The government can demand those records from the bank without violating your Fourth Amendment rights.
That feels incredibly invasive in a modern economy where it is impossible to exist without a bank account. You essentially have to surrender your financial privacy just to participate in society.
Yeah.
But the logic is consistent. You gave the info away, so it's not a secret anymore. Let's look at a more physical and, frankly, kind of amusing application of this rule from Rawlings v. Kentucky, the friend's purse rule.
It is a classic, highly tested law school hypothetical made real. A man realizes the police are about to arrive, so he frantically takes thousands of dollars worth of illegal drugs and stuffs them into his female companion's purse to hide them. The police search the purse, find the drugs, and charge him.
And he tries to argue that the search of her purse violated his Fourth Amendment rights.
Exactly. And the Supreme Court shut that down immediately. When Rawlings dumped his drugs into someone else's bag, he surrendered any legitimate expectation of privacy in those items. He gave up control.
Right.
He trusted a third party with his contraband. He assumed the risk. He had no standing to challenge the search of a purse he didn't own.
So we lose privacy in our bank records, and we lose privacy if we hide stuff in someone else's bag. But I'd argue it goes even further to a much more fundamental human interaction. What about my private conversations?
Conversations.
Yeah, if I sit in my living room and confess a secret to my best friend, is that protected?
Generally, the sanctity of a private conversation in a home is protected against outside government eavesdropping, like the wiretap in cats.
Okay, good.
But UT, under the crushing weight of the assumption of risk doctrine, established in the 1971 case, United States v. White, you run a terrible risk. If you have a conversation with a friend, and it turns out that friend is secretly a government informant wearing a hidden wire, Or if they later agree to record a phone call at the police's request, the Fourth Amendment will not protect you.
So by speaking out loud to another person, I assume the risk that they are a snitch.
Exactly. You trusted the wrong person. The Fourth Amendment protects you against the government intruding into your private spaces, but it does not protect you against your own misplaced trust in the people you choose to confide in.
That's wild.
The logic is that you voluntarily revealed your thoughts to a third party. If that third party decides to betray you to the state, the Constitution offers no remedy. Your privacy was destroyed the moment the words left your mouth.
It puts a philosophical chill on the very concept of friendship. And finally, in this section of losing privacy, what if I don't give my property to a friend or a bank, but I just throw it away?
You are referring to abandoned property. The rule is simple and absolute. Abandoned property is not protected by the Fourth Amendment. The defining case is California v. Greenwood.
This is the trash on the curb scenario we started the show with.
Yes. When you take your garbage, tie it up in opaque plastic bags, and set it on the curb for the municipal trash collector to pick up, you have voluntarily abandoned it.
Okay.
You have purposefully placed it outside the curtilage of your home, exposing it to the public, to scavengers, to raccoons, and, yes, to the police. The Supreme Court ruled that society does not recognize a reasonable expectation of privacy in refuse left for public collection.
If you are taking the bar exam, the assumption of risk doctrine is unforgiving, and you must know its boundaries. You lose Fourth Amendment protections when you abandon property on the curb. You lose it when you voluntarily give information to a third-party business, like a bank or a phone company. You lose it if you hide your contraband in an associate's bag. And you lose it if you trust a conversational partner who happens to be wearing a government wire. The moment you expose a secret to the world or to another person, the constitutional shield drops.
Exclusivity is the price of privacy.
We have covered your house, your car, your luggage, and your garbage. But what about the most intimate space imaginable, your actual physical body? We are shifting to Section 5, your literal self. Surely the Fourth Amendment provides the highest level of protection against the government searching our biology.
It does provide intense protection, but even here, the courts draw a sharp distinction between what attributes you expose to the public and what is kept internally hidden.
Let's start with the exposed attributes.
There is no reasonable expectation of privacy and physical characteristics that you constantly, inevitably display to the world. For example, the sound and cadence of your voice, or the specific style of your handwriting.
Right. Every time I speak to a cashier, I expose my voice.
Mhm.
Every time I sign a receipt, I expose my handwriting.
Exactly. Because you make these attributes public constantly, the Supreme Court ruled in United States v. Dionisio and United States v. Mara that a grand jury demand for a voice exemplar or a handwriting sample does not constitute a search.
That makes sense.
The government is merely asking you to produce, in a controlled setting, what you display to the world every single day.
But the sources bring up a much more recent case regarding something far more intimate than a signature. The government isn't just looking at how we write anymore. They're looking at our genetic code. Let's talk about DNA.
Maryland v. King in 2013 is a monumental, highly debated decision regarding bodily searches. The court ruled that when law enforcement officers make an arrest supported by probable cause to hold a suspect for a serious offense, taking a cheek swab to obtain a DNA sample is a reasonable search that does not require a warrant.
I find that staggering. A swab of my actual DNA, the blueprint of my existence, is taken without a judge's approval.
The Supreme Court equated the DNA swab to traditional fingerprinting and photographing during the booking process. They reasoned that the physical intrusion of rubbing a cotton swab on the inside of a cheek is minimal.
Okay.
More importantly, they argued the state has a profound administrative interest in accurately identifying the specific person they have taken into custody and cross-referencing that identity against unsolved crimes.
So the administrative machinery of the jail justifies the biological search.
Yes. The need for identification outweighs the minimal physical intrusion.
Okay, now we move into what is perhaps the most nuanced, fiercely litigated, and heavily tested area of physical searches on the MBE, the battle between blood and breath. This almost exclusively arises in the context of drunk driving arrests. Let's break down the mechanics of why the law treats these two bodily fluids so differently.
The legal distinction is rooted entirely in the physical mechanics of the test and the level of bodily intrusion. The Supreme Court has drawn a very hard line between a breathalyzer test and a blood draw.
Let's analyze the breath test first.
A breath test is considered minimally intrusive. It does not pierce the skin barrier. It does not extract a fluid. It merely captures and analyzes the air that you are naturally exhaling out of your lungs anyway.
Right.
Because the physical intrusion is so slight, the general rule is that police do not need a warrant to administer a breath test to a suspect legally arrested for drunk driving. It is considered a reasonable search incident to a lawful arrest.
But consider the alternative.
The blood test.
I'm struggling to see why, if the goal is to measure alcohol, the method matters so much.
Yeah. The method matters because of bodily autonomy. A blood test is a significant, literal physical intrusion into the human body. It requires a government agent or a medical professional acting at their behest to take a sharp needle, puncture the skin, enter a vein, and extract a vital bodily fluid.
It's way more invasive.
Very. The Supreme Court, in cases like Birchfield and McNeely, determined that this level of biological invasion is severe. Therefore, the general rule is that police DO need a warrant signed by a judge to compel a blood draw. They cannot routinely stick a needle in a suspect's arm just because they arrested them for a DUI.
The needle piercing the skin is the constitutional barrier. A breath tube is fine. A needle requires a warrant. But because this is the law, the general rule always has exceptions.
Yes, and these exceptions are where exam questions live. There are two major exceptions to the warrant requirement for blood tests. The first relies on the doctrine of exigent circumstances, which is legal shorthand for a true emergency where there is literally no time to find a judge.
This goes back to the 1966 case of Schmerber v. California.
Correct. In Schmerber, the defendant was in a car accident, taken to the hospital, and arrested for drunk driving. The police ordered a doctor to draw his blood without a warrant.
And the court was okay with that.
The Supreme Court allowed it because of the unique biological reality of alcohol. The human liver is constantly metabolizing and eliminating alcohol from the bloodstream minute by minute. The court reasoned that the delay necessary to draft a warrant application, find a magistrate, and get it signed would result in the physical destruction of the evidence by the defendant's own body.
The evidence is vanishing into the metabolic process.
Exactly. However, it is vital to know that later cases, specifically Missouri v. McNeely, clarified that the natural dissipation of alcohol in the blood does not create an automatic per se emergency in every single DUI case.
Because with modern technology, officers can sometimes get an electronic warrant on their phone in 10 minutes.
Precisely. The police still have to show that under the specific totality of the circumstances of that particular arrest, securing a warrant was practically impossible before the evidence disappeared.
So that is the emergency exception.
Right.
What is the second exception to the blood warrant rule?
The unconscious driver exception, highlighted in the 2019 case, Mitchell v. Wisconsin.
If a driver is unconscious, they obviously can't blow into a breathalyzer.
Right. The court ruled that if a driver is totally unconscious, the exigent circumstances doctrine generally permits a warrantless blood draw. The logic is highly pragmatic. An unconscious driver requires immediate medical attention anyway. A hospital is almost certainly going to draw their blood for medical diagnostics.
So they're getting poked anyway.
Yes. Since the blood is likely to be drawn regardless, and the driver's condition makes a breath test impossible, the police are permitted to authorize a sample for legal testing without waiting for a warrant.
If you are taking the bar exam, absolutely memorize this bodily matrix. Voice and handwriting exemplars. Public attributes. No privacy, no search. A DNA cheek swab during a routine booking for a serious offense. A reasonable search without a warrant. Treat it legally like a modern fingerprint. A breath test for a DUI. Minimally intrusive, no warrant needed. A blood test for a DUI. Highly intrusive, get a warrant. Unless the driver is completely unconscious, or the police can prove a true, time-sensitive emergency where the alcohol is rapidly metabolizing and a warrant is impossible to obtain. Master the difference between the breath tube and the needle.
That blood versus breath distinction is a guaranteed point on the exam.
We have spent a lot of time discussing the founding-era concepts of physical trespass, curtilage, and property. But the ink on the Fourth Amendment dried in 1791. How do these ancient rules apply when the government uses modern 21st century technology to snoop? Let's enter Section 6, the high-tech snoop.
Technology is the turbulent frontier where Fourth Amendment jurisprudence is currently struggling to keep pace. The courts are constantly trying to fit digital pegs into analog holes.
Oh, for sure.
But we do have some definitive rulings in the sources. Let's start by looking up. Eyes in the sky.
We're talking about police airplanes and helicopters flying over private property.
Yes. The cases California v. Cirolo and Florida v. Riley deal with aerial surveillance. The established rule is that police observation conducted from navigable public airspace does not violate a reasonable expectation of privacy and is therefore not a search.
Define navigable airspace.
Generally, that means flying at least 400 feet above the ground for a helicopter or higher for a fixed-wing plane in compliance with FAA regulations.
So if I build a 10-foot privacy fence around my backyard curtilage, and I am growing illegal marijuana plants inside that fence, a police helicopter flies over at 400 feet. The officer looks down, sees the plants, and uses that observation to get a warrant to raid my house. That is totally legal.
It is entirely legal. The court's logic is that any member of the public flying over in a commercial airliner, a private Cessna, or a news helicopter could look down and see the exact same thing.
Unbelievable.
Because you did not put a roof over the yard to protect it from aerial observation, you cannot claim society recognizes it as reasonably private from that specific vantage point.
The umbrella of curtilage doesn't protect against the rain if the rain is a police helicopter. Okay, what about technology that tracks our movements? Our cell phones are essentially homing beacons we voluntarily carry in our pockets.
And the Supreme Court finally reckoned with that reality in the landmark 2018 case, Carpenter v. United States. The government acquired months of historical cell site location information from a suspect's wireless carrier without a warrant.
Which tracks everywhere they go.
Yes. This data showed roughly where the phone and the suspect was located every time it pinged a cell tower.
Now, under the third-party doctrine we discussed earlier, Carpenter gave that data voluntarily to his phone company. Shouldn't he lose his privacy rights?
That was the government's exact argument. But Chief Justice Roberts, writing for the majority, essentially said enough is enough. The court declined to extend the third-party doctrine to historical cell site records.
They drew a line.
They did. They ruled that acquiring this data does require a warrant. The logic was the mosaic theory. While one single ping to a cell tower might not be private, compiling weeks or months of continuous location data creates a deeply revealing, intimate mosaic of a person's life. Their political affiliations, medical appointments, and romantic associations.
That's just too much data.
The sheer volume and inescapable precision of digital tracking fundamentally altered the privacy calculation.
So they need a warrant for my phone's location history. But what about tracking my car? This brings us to a highly specific exam distinction that I call the GPS trap. It involves two cases, Knotts and Jones. Let's guide the listener through this minefield.
This is a classic test of reading comprehension and timeline analysis. In the 1983 case United States v. Knotts, the police placed a radio tracking device inside a 5-gallon container of chemicals. Crucially, they installed the tracker before the suspect ever bought it. They got permission from the original owner of the chemical company to place the bug. Then, the suspect purchased the container, took possession of it, and put it in his car. The police used the tracker to follow his car to a drug lab.
Was monitoring that tracker a search?
The Supreme Court said no, it was not a search.
Why not? They're using a bug to track his car.
Because of the timeline. The police did not trespass on the suspect's property to install the bug. They installed it on the chemical company's property with consent. By the time the suspect put it in his car, the bug was already there. The court ruled the police were merely using technology to enhance their ability to visually follow him on public roads, which they could have done with tailing cars anyway.
Now, contrast that timeline with the Jones case we discussed way back in Section 1.
In Jones, the defendant already owned and possessed the vehicle. The government physically trespassed onto his private property, reached under his car in a public parking lot, and installed the GPS device without his consent.
So the exam trap is entirely about when the tracker is installed and who legally owns the item at that precise moment. If the government installs a tracker inside an item with the prior owner's consent before you ever take possession of it, monitoring it on public roads is just enhanced surveillance, not a search. But if the government physically touches or trespasses onto your property while you actively own it to install a tracker, it is a search.
Exactly. It is a subtle but critical property law distinction wrapped in a high-tech scenario.
Brilliant. Now, let's look at technology that doesn't track location, but enhances the human senses, specifically seeing through walls.
The seminal case here is Kyla v. United States. Police parked across the street from a suspect's home and aimed a thermal imaging device at the house.
Wow.
They were scanning for the massive heat signatures associated with the high-intensity halogen lamps used to grow indoor marijuana. The scan showed specific areas of the roof, and walls were significantly hotter than the rest of the house.
They didn't cross the property line, they didn't touch the house, they just
Yeah.
measured the heat radiating off it.
But the Supreme Court ruled that this was a search, and it required a warrant.
Really?
The court reasoned that the police used sense-enhancing technology that is not in general public use to explore intimate details of the interior of the home that would previously have been unknowable without a physical intrusion.
Because the heat tells a story about what is happening inside the sanctuary of the home.
Yes. If the court allowed thermal imaging without a warrant, they feared it would leave the homeowner at the mercy of advancing technology that could eventually see through walls with perfect clarity. The home must remain a fortress against technological intrusion.
Let's contrast the high-tech thermal scanner in Kylo with a decidedly low-tech enhancement. What if an officer is walking past my parked car at midnight and they shine a standard Maglite flashlight through my window to see what's on the passenger seat?
Not a search. The Texas v. Brown case makes this clear. A flashlight is ubiquitous. It is in general public use. Anyone walking their dog at night can shine a flashlight into a parked car.
Okay, so it's fair game.
Therefore, a police officer illuminating the interior of your car at night is legally no different than an officer looking into your car during the bright daylight. Using artificial light to replace the sun does not violate an expectation of privacy.
Okay, before we conclude, I want to synthesize a topic that has popped up in multiple sections. The canine sniff. Exam questions love dogs. Let's build a unified theory of the dog sniff for the listener based on the cases we've covered.
A unified theory of the dog sniff is highly effective. It all comes down to the geography of where the dog's paws are planted.
Okay.
If the police bring a drug-sniffing dog onto a constitutionally protected area, like your front porch curtilage in the Jardines case, the act of bringing the dog there is a physical trespass to gather information. It is a search. It requires a warrant.
But if the dog is in a public space?
If there is no physical intrusion onto protected property, the sniff itself is not a search. So, as we learned in Cabayes, if you are lawfully pulled over on a public highway and a dog walks around the exterior of your car, that is not a search. And as we learned in Place, a dog sniffing your luggage in the middle of a public airport terminal is not a search. The dog is only revealing the presence of contraband, which you have no right to possess privately anyway.
The location of the dog dictates the constitutionality of the sniff. And just to close the loop on testing substances, the sources mention the Jacobson case regarding chemical field tests. If the police legally find a bag of white powder and drop a chemical region on it to determine if it's cocaine, is that chemical test a search?
No. Much like the dog sniff in public, a chemical field test only reveals one binary fact, whether a substance is contraband or not. It does not reveal any legitimate private information about the powder. Therefore, conducting the chemical test does not compromise any legitimate privacy interest.
For the bar exam, lock in this high-tech and sensory matrix. Police helicopters flying at 400 feet. Not a search. Demanding months of historical cell phone location data. Requires a warrant. Slapping a GPS on a car you actively own. Search. Monitoring a bug installed in a bucket before you bought it. Not a search. Scanning a house with a thermal imager. Search. Shining a common flashlight into a car window. Not a search. A dog sniffing on your private front porch. Search. A dog sniffing your car on the side of the highway. Not a search. A chemical field test on powder. Not a search.
If you can articulate the reasoning behind each of those outcomes, you are well on your way to conquering the Fourth Amendment section of the exam.
Let's zoom out and look at the massive landscape we have just traversed. We have decoded a tremendous amount of constitutional law today, from the absolute necessity of proving government action to the philosophical shift of protecting people, not places, traversing the sanctity of the home, the diluted privacy of cars, the bloodstreams of drunk drivers, all the way to GPS trackers and the mosaic theory of cell phone data.
And as I noted at the beginning, the true value of this knowledge is in its application. The central nervous system connecting all of these seemingly desperate, sometimes contradictory rules is the concept of the reasonable expectation of privacy. Where you choose to go, what you choose to carry, and most importantly, what you voluntarily expose to the rest of the world completely dictates the level of your constitutional rights.
It's all connected.
The Fourth Amendment is not a static wall. It is a dynamic, breathing shield that expands and contracts based entirely on context.
It is all about context. And that context brings me to a final provocative thought for you, the listener, to ponder as we close out. We spent a significant amount of time exploring the assumption of risk and the third-party doctrine. The brutal reality that we lose our privacy when we give our information to a bank or a phone company, or when we throw our trash on the curb.
It's a lot to process.
But think about the trajectory of the modern world. We are becoming deeply, intrinsically integrated with third-party technologies inside our most sacred space,
Hmm?
the home. We have smart speakers constantly listening in our kitchens. We wear health trackers that monitor our heart rates and sleep cycles. We have internet-connected security cameras recording our driveways and living rooms, uploading that data to corporate servers.
The sheer volume of intimate behavioral data we willingly generate and transmit to corporations every single day is historically unprecedented.
Exactly. So my question is this. As we voluntarily share more and more of our private lives with these tech companies for the sake of convenience, how much of our existence will eventually fall under the assumption of risk doctrine? If our homes are filled with microphones and cameras constantly sending our data to third-party servers, will the Fourth Amendment's ultimate protection of the home eventually become a relic of a disconnected past? Because if the government can simply subpoena Google, Amazon, or Apple for a complete digital mosaic of our lives inside our houses, they might not ever need to physically knock on our front doors again. The fortress may have already been bypassed.
That tension between technological convenience and constitutional privacy is, without a doubt, the defining Fourth Amendment question of the 21st century.
And on that profound, perhaps slightly terrifying note, we want to warmly thank you for joining us on this deep dive. Whether you were about to sit for the MBE or you were just passionately pursuing a deeper understanding of the laws that govern a free society, we hope this extensive conversation has illuminated those legal muddy waters and given you a reliable map to navigate them. Best of luck on your exam, stay fiercely curious, and we'll catch you next time.